Thank you, Mr. Deputy Speaker. I beg to move that the Bosnia and Herzegovina Sanctions EU Exit Regulations 2020 be approved. The 9 instruments before us were laid between July 2019 and December 2020 under the powers provided by the Sanctions and Anti-Money Laundering Act 2018, also known as the Sanctions Act. As the House will be aware, on the 31st of December 2020, the UK took control of its sanctions policy, and we now have a full suite of sanctions regimes at our disposal under the Sanctions Act. This provides the legal framework within which the UK may impose, update and lift sanctions, whether autonomously or in line with our UN obligations now that we have left the European Union.
My honourable friend is aware is a very serious campaign to take action against China at the moment because of the treatment of Uyghurs, and we're asked to produce motions on genocide. But it seems to be that now we've left the European Union, action is now in our hands. So would he confirm to me that we can now take very robust action against the Chinese government in terms of sanctions, perhaps against the fashion industry, importing cotton from that part of China. So we now have freedom to act if we want to, and I hope the government will.
I thank you for the point that he has made. I will come into a bit more detail about the framework within which we can operate, and he will understand that the government chooses not to discuss future sanctions it may impose to prevent either the movement of monies or other things that we might approach. But I do absolutely hear, and my colleagues in government will absolutely hear, the point that he has made. Our sanctions regime is the foundation for an independent sanctions policy in support of our foreign policy and national security interests. With this framework in place, the UK can use sanctions to act as a force for good in the world. Working with partners, both old and new, we can collaborate to project our values and tackle unacceptable behaviour wherever we find it. Our global human rights regime is just one example of this. Of course, where collaboration is not possible or where swift leadership is required, we now have the freedom to act, as we did with Belarus and most recently in relation to Zimbabwe. On Monday, we designated 4 security sector chiefs who were responsible for the worst humanitarian rights violations committed against the people of Zimbabwe since President Mnangagwa took power, including the deaths of 23 protesters. Our sanctions send a clear message that those responsible for such acts will be held to account. In order to establish individual sanctions regimes within the framework of the Sanctions Act, we are required to lay statutory instruments. Amongst other things, these instruments set out the purpose of the regime, the criteria for designation, the measures imposed, exceptions and licensing arrangements, and the offences and penalties for contravention of these measures. Of the 9 instruments we are considering today, 7 transition existing EU regimes into UK law. The UK is at the forefront of developing multilateral contributions on sanctions and has played a large part in shaping the EU's approach. As a result, the measures contained in the UK's sanctions, such as asset freezes and travel bans, are intended to have substantially the same policy effect of those in the regimes that they replace. Certain types of sanctions measures, such as asset freezes and travel bans, apply to those who we designate. The instruments themselves do not specify which individuals or entities will be designated. Designations are instead made through an administrative process and published on the UK's sanction list. Officials assessed all those designated under EU regimes against the test established in the Sanctions Act and UK policy objectives before the end of the transition period. The vast majority of EU designations met those criteria. The two remaining instruments amend other statutory instruments that established sanctions regimes. These amendments are designed to ensure that our entire suite of sanctions legislation is consistent and clear in its provisions as is possible. Many regimes contain the same sanction measures, and consistency in language promotes consistency in interpretation, application, and enforcement. British businesses often export goods or provide services to more than one country that is subject to sanctions, and any inconsistency in the wording of the legislation can cause confusion and increase their compliance costs. The amendments also ensure that UK persons in the Crown dependencies and overseas territories are not unduly impacted by extraterritorial application of UK law. They create an exemption for the extraterritorial prohibitions so that a licence from the authorities in that jurisdiction is sufficient to authorise UK persons' conduct there. Those persons do not need to also obtain a licence from the UK authorities in order to avoid committing an offence under UK law. I will elaborate a little further on the purposes of the 7 regimes which these instruments establish. The Bosnia and Herzegovina sanctions regulations are aimed at promoting peace, security and stability in Bosnia and respect for its sovereignty and territorial integrity. They are also intended to encourage compliance with and the implementation of the General Framework Agreement for Peace, which established Bosnia and Herzegovina as a single sovereign state. The regulations permit the imposition of financial and immigration sanctions. Bosnia and Herzegovina is one of the countries in the Western Balkans most at risk of instability. Its domestic political situation is affected by institutional dysfunctionality, diverse ethno-nationalistic rhetoric, attempts to undermine the functions of the state and its institutions, and challenges to the General Framework Agreement for Peace. These sanctions are a public demonstration of our enduring commitment to promoting stability and security in Bosnia and Herzegovina. The Burundi sanctions regulations aim to encourage the government of Burundi to respect democratic principles and institutions, the rule of law and good governance in Burundi. Also to encourage them to participate in negotiations with political opponents in good faith to bring about peaceful solutions to the political situation in Burundi. Refrain from policies and activities which repress civil society in Burundi, and comply with the international humanitarian rights and respect human rights. They permit the imposition of financial and immigration sanctions. Following the elections in May 2020, there was a peaceful transfer of power to a new president in June 2020. Nevertheless, we continue to have concerns about the human rights situation, such that we believe that these sanctions continue to have a role in promoting the respect for human rights in Burundi. The cyber sanctions regulations are aimed at preventing certain types of cyber activity which undermine the integrity, prosperity or security of the UK or any other country. They are also intended to prevent certain types of cyber activity which cause economic loss or prejudice commercial interests, undermine the independence or effective functioning of an international organisation, or otherwise affect a significant number of people in an indiscriminate manner. The regulations permit the imposition of financial and immigration sanctions. The cyber threat is growing, with attacks increasing in their intensity, complexity and severity. Malign actors in cyberspace are able to carry out attacks on other countries' critical national infrastructure, democratic institutions, businesses and media. These sanctions demonstrate that there are consequences for such attacks and restrict access to the resources for those who would seek to carry them out. The Guinea sanctions regulations aim to encourage the government of Guinea to properly investigate the violent repression that took place on the 28th of September 2009 and its aftermath, as well as holding those responsible to account. Sanctions make clear that these events, in which over 150 people were killed, have not been forgotten and their perpetrators should face justice, as well as providing a deterrent for the future. The regulations permit the imposition of targeted financial and immigration sanctions. The misappropriation sanctions regulations are aimed at deterring and providing accountability for the misappropriation of state funds from a country outside the UK. They permit the imposition of financial and immigration sanctions. Rather than establish geographic regimes as existed under the EU legislation, this instrument creates a single thematic regime where designations can be made in respect of misappropriation of state funds taking place anywhere outside the UK, allowing for greater agility and flexibility. Corruption, and in particular misappropriation of state funds, has a significant negative effect on national and international prosperity, security, and governance. The cost of corruption worldwide is estimated to be over 2% of global GDP, and these sanctions are part of our wider strategy to combat this issue. The Nicaragua sanctions regulations are aimed at encouraging the government of Nicaragua to respect democratic principles and institutions, the separation of powers and the rule of law, refrain from the repression of civil society, and the respect of human rights. The regulations permit the imposition of financial and immigration sanctions. These sanctions function as a clear signal of our intention to maintain the pressure on the repressive Ortega regime, and as a tool through which we can exert this pressure. The unauthorised drilling activities in the Eastern Mediterranean sanctions regulations aim to discourage any unauthorised hydrocarbon exploration or production activities in the territorial sea or exclusive economic zone of the Republic of Cyprus or on its continental shelf. They permit the imposition of financial and immigration sanctions. We recognise and have consistently stated our support for the sovereign right of the Republic of Cyprus to exploit the oil and gas in its internationally agreed exclusive economic zone. Cyprus's oil and gas should be used for the benefit of Cypriots. These sanctions demonstrate our opposition to the unauthorised drilling and the violation of other states' sovereignty. In conclusion, Mr. Deputy Speaker, sanctions are a key part of the UK's foreign policy toolbox and feature in many of our political and diplomatic strategies. We use them to change unacceptable behaviour, either by coercing or constraining those involved, or by sending a political signal that their actions will not be tolerated. They also contribute to our efforts to uphold and defend the rules-based international order. The UK has long been a global leader on sanctions, and this will not change now that we have left the European Union. Our independent sanctions policy allows us to use sanctions to achieve maximum impact, working in a way that is agile, expertise-driven, and in support of our values, and enables collaboration with both new and established partners. International cooperation is at the heart of our polity. Sanctions are most effective when implemented and enforced collectively, and we will continue to coordinate closely with our European and other international partners on sanctions. These regulations are a crucial part of the legal edifice which underpins our sanction policy, and of which the Sanctions Act is a keystone. With them in place, we can promote and protect security, stability, and prosperity both at home and overseas, call for accountability and justice, and deter human rights violations and abuses. In short, Mr. Deputy Speaker, we can project the UK as a force for good in the world. I welcome the opportunity to hear the views from members about these regulations and to answer their questions, and I commend these regulations to the House.
The question is the motion relating to Statutory Instrument 2020 number 608 as on the order paper. Stephen Doughty.
Thank you, Mr. Deputy Speaker, and can I thank the Minister for his introduction to these motions, and can I be clear that the opposition welcomes these motions to roll over the European Union sanctions regimes into UK legislation and to clarify and ensure the applicability of a series of other measures. And they, of course,